citations AR and the Chief Constable of Greater Manchester.
Yes, Mr. Southey.
My Lords, I appear with my learned friend Miss Davies. The Chief Constable is represented by my learned friend Miss Richards, Queen's Counsel, and the Secretary of State is represented by my learned friends Mr. Moffat, Queen's Counsel, and Mr. Knight.
Yes.
Obviously, this has been listed, and we appreciate the opportunity to address the court about this, to consider the effectively the implications of the Court of Appeal's judgment regarding Article 6.2. And in summary, our argument is that the limited information that was actually provided in this criminal records certificate reflects essentially the obligations imposed by Article 6.2, but that then weighs against disclosure because it makes it very difficult for an employer to assess the relevance of the underlying allegations in an informed manner. Now, the starting point in relation to that is to perhaps remind the court of the very limited information that was included in the enhanced criminal records check. That is it's in the core volume at page 379, but it's easier to read, to be frank, in the statement of facts and issues because it's not a brilliant copy. And that statement of facts and issues, the relevant paragraph in the statement of facts and issues is at paragraph 7, page 50 of memory stick page 50.
Yes.
And the court will remember essentially that the criminal records certificate, or the enhanced criminal records certificate, essentially recorded accurately what had happened, in the sense it recorded that there had been an allegation and what followed. What it didn't do was express any view as to the reliability of the allegation. And certainly our submission would be that on the reasoning of the Court of Appeal regarding Article 6.2, that is not surprising because there would have been an issue on the reasoning of the Court of Appeal we would submit. It also didn't include any summary, and that may be unrealistic to expect it to include that, but it didn't include any summary of essentially the evidence. So, for example, it said nothing about the forensic evidence, and that may be regarded as being of some significance because, as the judge's summing up recorded, the only DNA evidence in this case came from another man, not the appellant. So the certificate was limited and restricted to essentially, as I say, a summary of the history of the allegation, followed by and the fact it was then followed by a trial that resulted in acquittal. Now, although that doesn't include any assessment of the likelihood of the allegations, we would certainly submit that a well-advised employer may well assume that there were, or a well-advised licensing authority may well assume that there was an implicit assessment by the police that the allegations were true. And that's because it would have been disproportionate, essentially, to disclose material if there was no risk that an offence had been committed. The supplementary submissions of the Greater Manchester Police, paragraph 20, I won't take the court to it, memory stick page 2093, accept correctly that the purpose of disclosure is to indicate matters that may indicate risk.
So which paragraph is that?
It's paragraph 20 it's tab 2 of the supplementary bundle. It's the first set of supplementary submissions from Greater Manchester Police.
May indicate a potential risk.
Yes.
So your proposition, I think, Mr. Southey, was that the well-advised employer or licensing authority may well assume that the implicit assumption by the police is that the allegation is true. Is or might be?
Might be true. Sorry.
All right.
Yep. And that's also consistent with, of course, the statutory scheme in the sense that Section 113B requires the Chief Constable to form a reasonable belief that the material is relevant, and that's obviously been interpreted, the whole of the statutory scheme has been interpreted as imposing a requirement of proportionality. All of that is consistent with and explains why the statutory guidance that has been issued to the police, and one needs to be a bit cautious here, and I'll just highlight this at the moment. There are two sets of statutory guidance, essentially. One that's been issued to the police to guide them in their functions, and one that has been issued to the employers. And I'll come back to the second set in a moment. But the statutory guidance issued to police, as we saw, I think, on the last occasion, because there was a lot of argument about, essentially, about the meaning of that, tab 53, volume 5 of the materials, that statutory guidance indicates that the police are required to assess whether or not the material comes from a credible source. It's memory stick page 2041, and it's paragraph 18, which talks about the need to assess whether the material comes from a credible source, and then in fact also paragraph 22, which gives guidance on assessing proportionality, refers to the need to take account of a range of factors, including credibility of the allegation.
We may well have covered this at the previous hearing, but forgive me if we did, but I've forgotten. This guidance obviously postdates the
Yes.
certificate that we're concerned with, but are you inviting us to deal with the appeal with regard to the current guidance?
I think on the last occasion there was a submission about it, and I'm just trying to make sure I'm not inconsistent with what I said on the last occasion. I think what we submitted on the last occasion was that the court has to bear in mind, obviously, that there wasn't any guidance at the relevant time, because ultimately, I suppose the fundamental issue is the proportionality of disclosure in these circumstances. But we have also recognised that in reality, the court is going to be conscious of the fact there is now this guidance. And this guidance, to a large extent, we would also accept, is effectively reflective of the statutory scheme, in the sense that it is an attempt to give further guidance as to the correct approach to proportionality. So, for example, we've obviously always argued that paragraph 18 essentially comes close to imposing a balance of probabilities test. And if it's indicated by that if that's a correct interpretation, it becomes difficult to justify, even before the guidance, disclosure in circumstances where the balance of probabilities test isn't met, because the guidance indicates that the experience of public authorities is that it's only in circumstances where the balance of probabilities test is met that disclosure is needed. So, my Lord, I hope that's an answer to my Lord's question.
Yep.
Now, all of that material indicates, as I say, that the well-advised employer or licensing authority will tend to assume, we would submit, that that disclosure indicates at least some sort of assessment that there is some degree of reliability in the material and the allegations. And that's consistent with the guidance issued by the Local Government Association in relation to licensing in particular. That's in the supplemental bundle, page, it's at tab 8F, and it's at page 2292. And that again postdates the facts of this case, but in some senses it illustrates exactly the point that we're trying to make. One sees in the under the heading use of soft intelligence, and I'll come back to this passage because it's relevant for other reasons, one sees in the third paragraph under that heading, starting with the words "when dealing with allegations," it goes on to say, a decision maker must not start with any assumption about them. Allegations will have been disclosed because they reasonably might be true, not because they are definitely true.
Yes.
Now, so one sees that, as I say, a well-advised employer may well think there is reliability. The problem, obviously, is that on the facts of this case, and we would say for good reason, and that good reason is Article 6.2, the actual disclosure says nothing about reliability and doesn't say where on a spectrum of reliability the allegations fall. And that's consistent with the judgment of the Court of Appeal. The judgment of the Court of Appeal in paragraph 60, I'll come back to that judgment, it's at memory stick 159, in rejecting an argument essentially that there was a breach of Article 6.2 because the implication was that somebody might be guilty of the offence. The Court of Appeal concluded at the last line or last sentence in paragraph 60, the effect of indicating facts from which others may perceive a risk does not contradict the effect of the verdict. So the Court of Appeal was recognising that ultimately, because of the limited nature of disclosure, it's for others to perceive what the risk was.
But where do you say that they are accepting your proposition that it is Article 6 which inhibits an expression of opinion?
Yes.
Where?
Well, I was going to come, but I will deal with it now, my lord.
No, do it in your own terms.
If I can do, can I come back to it, just because I've set up the context of this? What we would say, just to set up the context, is that if employers are going to make use of this material, if their decisions are going to be proportionate, they do need to try and assess the reliability of the material. If one thinks about, and I won't take the court to it, the court's been to it several times unless the court wishes me to, the judgment of Lord Newburger in L, the reference is memory stick page 534, paragraph 81. Lord Newburger disclosed, or referred rather, to the need for an assessment of reliability of allegations before disclosure. Why does that need to be assessed? It's because they must be relevant to the employer, and the employer needs to, if it's going to reach an proportionate decision, also be able to assess reliability. Consistent with that, the guidance we've just seen on counsellors, or the guidance issued to counsellors rather, the same page 2292, under decision making, refers to the need for counsellors to be 51% certain that a person may not be a fit and proper person. In other words, counsellors being given guidance that they should be applying balance of probabilities in licensing decisions. Now, in the case of an acquittal, and if the acquittal is the only thing that's being relied upon, it's difficult to see how it can be said that you can be 51% certain that a person is not a fit and proper a person based on the acquittal, unless one can also be satisfied that the person is 51% likely to have committed the crime, despite the acquittal.
Slightly odd, 51% certain the applicant may not be a fit and proper person, which is not quite what you said.
Well,
It's difficult to know how you can be 51% certain about something which may or may not be true.
well, I mean, the use of the word may, probably in that context, certainly this is the way I read it, reflects the fact that, of course, even if it's 51% certain, one can't be certain that the person is a fit and proper person. Probably the word may is unnecessary in that context. But it's...
To be 100% certain. I didn't want my teenage daughter to be a pillion passenger on a motorbike without being 100% certain that she would actually be involved in an accident.
No, but it is. I mean, on the face of it, if one is applying a fit and proper person test, and one is looking at that on the basis of an allegation, it's difficult to see how one can say one's 51% certain someone is not a fit and proper person, unless one is 51% certain the person actually committed the underlying act that's relied upon. I mean, if a person is only 10% likely to have been involved in some allegation, and I'm moving away from the facts of this case for the moment, then it's only, and that's the only allegation against the individual. It's difficult to see how one can say one can be more than 10% certain the person, in fact, is not a fit and proper person.
Well, is there not some basic incongruity about using percentages of certainty? What does 10% certain mean?
Well, Can I say two things about that? Firstly, and perhaps I should clarify what our position is in relation to this guidance. I'm not necessarily saying this guidance is necessarily essential for counsellors, in the sense that if a counsellor were to apply a 49% test, it might well be that they could justify that as being a lawful decision. I'm not saying this test reflects necessarily the statute. And what I am saying is that what this guidance recognises, unsurprisingly, is that where one actually has a spectrum in terms of reliability of allegations, one has to try and work out where on the spectrum a particular allegation falls. That's all I'm saying. I'm not saying there's any magic in the 51%.
Well, it's not your fault, Mr. Southey. The 51% certain is a misnomer anyway, isn't it?
Yeah.
And it's a bit like the question that you sometimes get asked by juries: will you put the standard of proof in percentages? To which the answer is always no.
Yeah.
Because it can't be done. There's no way you can distinguish between 52% and 48% or whatever. But it's not your fault because it's there in this document.
Yes. No. All I'm relying on it. I do not pretend this document is well drafted. What I am relying on it for is an indication of the fact, unsurprisingly, that a licensing authority is likely to know where on a spectrum a particular allegation falls. And going back to my Lord's question...
Why can't they just ask, is there a risk?
Well, but the problem is they need to ask, is there a proportionate risk?
All right, is there enough risk not to take the chance of appointing him?
Absolutely, my Lord. But that then raises the question of... they firstly, if they're going to answer that question, need to assess what is enough risk, and then assess whether this risk is over that.
Yes, I follow that. All right.
Yeah.
And you say that has to be thought of in semi-mathematical terms.
It doesn't have to be, well, no, I'm not saying it has to be assessed in, but I am saying that in reality, on where there's a spectrum between something that is just possibly true to something that is almost certain, one does need to sort of think about where. And going back to my Lord's question, I'm not suggesting in reality decision makers need to sit down and say this is a 30% reliable allegation or something along, because that's just not the way people work.
It might be better to call it a 10% chance of being true or a 50% chance of it being true.
But even then, I'm not suggesting in reality decision-making processes will involve people sitting down and saying this is 10%. There is a 10% chance this is true. Yeah. What I am saying, though, is that they need, in a sort of broad sense, an idea as where on the spectrum an allegation fits.
Right. Well, you've limited time, so we must let you get on.
Can I say that, add to that, that obviously on the facts of this case, it's potentially particularly important that where on that spectrum, that there is an assessment of where on that spectrum these allegations fall, because, of course, as the court probably will remember, the approach of the High Court judge, and this hasn't been challenged, was to reach the conclusion that no firm conclusion could be reached as to whether this was more likely than not to be true. So on the face of it, this is a case where the allegations don't meet the balance of probabilities test. Now, my Lord, going then to the question that my Lord Hughes asked me a moment ago, which is what do we say essentially about the Court of Appeal judgment? The Court of Appeal judgment perhaps ought to be set, just to put it in context, in the context essentially of what was being argued by the respondents to this appeal. Memory stick page 257 sets out the Secretary of State's arguments, which essentially were relied upon by Greater Manchester Police. And it's paragraph 58.
Yes.
And one sees there that what was being said essentially was there wasn't a problem with Article 6.2 because essentially there was no assessment of the underlying evidence, and as a result there was no comment on any indications of possible guilt. And in my submission, what effectively happens is that the Court of Appeal then adopts that submission. if one goes to the Court of Appeal's judgment, the key passages are paragraph 54 to 60. And those passages essentially start with a statement, unsurprisingly, that the court was going to follow the judgment of Lord Hope in Adams, which indicated that it was not open to the state to undermine the effect of an acquittal. It then, perhaps unsurprisingly, also referred to Allen, which I'll come to, the Grand Chamber decision, which sought to analyse in some depth the correct approach to the presumption of innocence. Noted that there was no single approach. That's correct in my submission, not least because when one comes to Allen, one sees quite a clear distinction drawn between situations where somebody has been acquitted on the merits, which is this sort of case where there's been a jury verdict, and the situation which was in fact the situation in Allen, where somebody had been acquitted in what might be described as technical grounds and no retrial had been ordered. And then the reference to the language used being of importance. And that is also something one sees in Allen, and indeed one sees later in the Court of Appeal's judgment. Paragraph 56 is perhaps the first point at which reference to language can be seen. And paragraph 56 is where it said there was no violation of Article 6.2, in part because the statement was extremely limited. And there was no aspersion cast on the correctness of the acquittal, and nothing to suggest the appellant was guilty. That focus on language, we would submit, is a focus on the language actually in the certificate. And what one sees at paragraph 58, which has also been a certain amount of submission about, is further reference to language. But in our submission, what ultimately paragraph 58 does is it focuses on the fact that it was the criminal record certificate that essentially was the public statement. And so the reviewing officer's reasoning, one sees that in the last full sentence, so the reviewing officer's reasoning, which is what was partially criticised, didn't appear to cause a problem. That reasoning of the reviewing officer is, in our submission, what is anticipated, or what is described rather as unfortunate language at the start of paragraph 58. And that reasoning essentially was reasoning that said, I can be satisfied on balanced probabilities that paraphrasing, that there was guilt here. And the implication of that is that there would have been a potential issue if the criminal record certificate had included the reasoning of the decision maker.
What do you say about the sentence in the middle, beginning nonetheless?
Well, in my submission, it has to be read in context. Firstly, in light of, as I say, what the end of paragraph 58. So it's saying, what it's saying is essentially a statement isn't inherently objectionable in Article 6.2 terms. So if it's in the reasoning, it's not necessarily inherent, and it needs to be read with Allen. And Allen recognises in some circumstances, and we would say the sorts of circumstances that we're talking about when we're talking about the certificate, in some circumstances saying essentially we think you're more likely than not to be guilty of an offence is a breach of Article 6.2. The difficulty is deciding when essentially a public statement of that nature is a breach of Article 6.2.
Do you say that if it's made by an organ of the state, it is a breach?
Yes.
Always?
In circumstances where there's been an acquittal on the merit.
So supposing there's an acquittal on the merits in a case of a closed head injury to a child.
Yes.
And subsequently an organ of the state, the Social Services Department of the local authority, brings care proceedings relying on the same allegation, but of course having to prove it to an entirely different standard. is that a breach of Article 6? And if it isn't, why isn't it?
Well, in part of the answer to that may be that of course, in family proceedings, it may well be that there's no public statement of that.
Oh, well, no, that won't do. So there often is.
Well, but there isn't necessarily, but
Yes. I mean, the proceedings may be conducted in chambers, but they're very much public in the sense that the findings are made public.
well,
Well, let's assume that
Anyway.
let's assume that it is made public.
okay.
Yes.
Let's assume that it is made public. If it's made in public, do you say that there is inevitably and invariably a breach of Article 6 too?
It depends on I would say, it depends on the language used to some extent. But the mere use of balance.
I mean, the language used is bound to be. We say that this child is at significant risk of future harm from this parent because of what happened to the other child. That's the common situation. It happens all the time.
Yes.
Now, it may be that there's a reason why it isn't a breach of Article 6,
But
I'm just wondering what it is.
well, the reason I was focusing on the language was that, I mean, it seems I would certainly submit that quite often one can express those sorts of findings without necessarily saying that there was without saying that it's criminal liability, essentially.
Of course. But what you're doing is finding that the parent killed the previous child. You're finding it on the balance of probabilities. And the whole point is that the difference of standard of proof justifies in what on the face of it might appear otherwise to be inconsistent findings between the criminal court and the family court. You could say the same about a criminal court and a disciplinary hearing, internal disciplinary hearing, or between a criminal court and a subsequent tort action.
But
Now, all I'm trying to get at is, I'm sure you're right up to a point, what I'm trying to get at is why are those assertions by state authorities in some cases, if you're right, not breaches of Article 6? Because it's very clear they're not.
But the point I would make about the family proceedings was what a judge would probably do, or what I would submit a judge would be expected to do in the family proceedings, would be, as my lord said, make a finding that the death had been caused by the parent. That wouldn't necessarily be the same thing, and one wouldn't use the language generally of murder. One wouldn't say, on balance of probabilities, I'm satisfied this parent murdered the child. And
Does that make enough difference?
Well, it does, because in some senses you are considering a different issue to some extent.
Right. So the finding that he did it, which is what I think you're talking about in the present case, doesn't necessarily carry with it the implication that he's guilty of an offence.
Well, except in this particular context, if this particular context, and this is a distinction I'd use, in this particular context, the problem is that it is the criminal. It's the act, isn't it? It is the.
It doesn't matter whether it's punishable as a criminal offence or not. What matters is the act, because it's the risk of future behaviour of this kind which is relevant to the licensing or the giving of employment or whatever. It's not punishment.
It's not.
In that sense, it's rather similar to the care proceedings.
But the difficulty. One's talking there potentially about the response of the employer. The difficulty for the, and the difficulty for the police when issuing a certificate is how can they express, and we submit they can't. How can they express a view? And that's essentially all they will be doing about the reliability of the allegations without overstepping.
Well, that's exactly the question. Okay, I've got your answer. Thank you very much.
It may be, in reading the Allen judgment, the Grand Chamber there discussed civil compensation claims, and they discussed disciplinary proceedings. They cited a previous judgment of the court, but I don't know what it says, about childcare proceedings, case of OL against Finland. The point they seem to emphasise in relation to civil claims and disciplinary proceedings is that you have a judicial body carrying out an independent assessment of the facts, and it's not forestalled from reaching its own conclusion on the facts, applying the appropriate burden of proof by the fact that a different judicial body had reached a particular conclusion in the criminal proceedings. The problem in the present case is that there's not a separate judicial assessment being made.
No.
It's rather what the relevance is of the information about the acquittal for a licensing authority forming a view about whether somebody is a fit and proper person.
Well, Lord, yes, I'd agree with that, and that's why one has a much more acute problem here, because effectively all the public authority that's issuing the certificate will do is give a statement essentially about whether or not they believe the person has been guilty of an offence. And so whatever the distinctions, and my Lord is right, there were distinctions drawn in Allen about civil proceedings and disciplinary proceedings, and they were drawn essentially on the basis of standard of proof, as well as certainly I think in relation to disciplinary proceedings, the issues are not necessarily the same.
Yeah.
One then sees paragraph 126, which is obviously what I would emphasise. Allen is, for my Lords, it's at volume 6, the new supplemental bundle of authorities, tab 58.
Quoted at length by the Court of Appeal.
It is quoted, and there's no suggestion the Court of Appeal were not applying Allen. And one sees there the concerns essentially being expressed that, or the ruling of the court, that essentially language was of critical importance. Particularly, we would emphasise, if one goes back to paragraphs 120 to 122, that is where the distinction that I drew between cases where there's been acquittals on the merits and in cases where there's been acquittals on more technical grounds is drawn. And one sees, in fact, in Allen, because Allen was a situation where the conviction was merely quashed as being unsafe, one sees that the court then focused on that, paragraph 127, for example, where the court talks about how, in circumstances where the conviction was unsafe, the reasoning essentially that was challenged didn't undermine that, because there was nothing to say the conviction wasn't unsafe in that reasoning. But, my Lords, we do come back to, when one looks at in particular paragraph 126 of Allen, it becomes quite difficult in our submission to see how a criminal records certificate could, for example, say an allegation was made of rape, there was an acquittal. Having looked at the evidence, the view of the police still remains that this acquittal is perhaps more likely than not to be, or this allegation rather is more likely than not to be true. Because that is then expressing a view, that is falling into territory, section 126 territory, or paragraph 126 territory. But the problem is, unless there is that sort of statement, the employer is left to assess risk without any real guidance. And that is particularly concerning in light of a couple of factors. Firstly, I won't take the court through it, not least because I'm conscious of time, but the court will remember that on the last occasion we drew attention to the fact that the European Court of Human Rights has expressed concern about the stigmatisation of people following acquittals. And MARPA is the authority for that, and I'll give the court the reference, it's volume 1, tab 50, memory stick, page 2001, paragraph 122. And secondly, that risk of stigmatisation is particularly significant in this context because the courts have recognised that employers may well be risk averse. The reference we would give to that is L, Lord Neuberger, paragraph 69, which is volume 1, tab 5, and T, volume 4, tab 39, memory stick, page 1679, where Lord Wilson expressly rejected an argument rather than employers could be relied upon to decide what was relevant. Did that, noting the risk of defensive decision-making. And that's consistent with the only study either party's been able to identify. That study is at tab 8A of the supplemental bundle. And it's not as positive as my learned friend representing the Secretary of State suggests. The executive summary...
So which page?
Sorry, it's memory stick page 2128. The executive summary describes there, for example, how, and this is focused on people who have a criminal record, but the executive summary refers to only 18% of people actually employing someone with a criminal record. It refers to ex-offenders having a largely negative reputation. Refers to 3/4 of employers saying they would use information. And it refers to employers perceiving ex-offenders as not having soft skills such as honesty and reliability. And finally, it talks about how the type of offence is significant. So, for example, driving and alcohol convictions, perhaps unsurprisingly, are not regarded as significant. One would assume that sexual offences are regarded as the other end of the spectrum. So all of this suggests, unsurprisingly, entirely consistently with the concerns expressed by people like Lord Neuberger in his judgment, that, that there is a real problem potentially for people who are subject to adverse disclosure in an enhanced criminal records check. There is a real risk that an employer will misuse the information, and our submission basically is that risk is enhanced in circumstances in which the employer gets no real guidance as to the reliability of that information. Now, the guidance to prevent misuse is very limited. There is nothing in that guidance that prevents an assumption of guilt. There is nothing that requires any sort of assessment of the strength of the allegations. And there are aspects of the guidance that essentially appears to equate allegations with, in fact, convictions. The statutory guidance is at tab 8E. I think this is the second statutory guidance, as I indicated. It's the statutory guidance intended for employers or licensing authorities, people who are registered persons who are supplied with data. And as my learned friend, I think my learned friends accept, there is nothing in this that expressly deals with the position of people who are not in fact, who haven't in fact been convicted of an offence. All, effectively, it says, as far as we can see, that's relevant is firstly, at page 2273, under the heading of suitability policy, that there is a requirement for a written policy on the suitability of ex-offenders. It doesn't actually say anything at all about people who are subject to allegations that haven't been proven. And at paragraph 4, it talks about how there's a need to discuss the contents of disclosure before withdrawing an offer. It doesn't say, though, what should be discussed, and in particular, it doesn't say whether or not there should be any attempt to assess with the person who's been made an offer the reliability of the allegations. Now, this is, as I've already indicated, statutory guidance. This morning, I think all three parties managed to turned up with section 122 because we all worked out that that was a document that had somehow been overlooked. Section 122 is the provision that provided for the issuing of the code, and provides also for sort of what the consequence provides. Also contains provisions rather governing the consequences of failure to comply with the code. And at section 3A, it provides that registration may be suspended. if essentially if there's been a failure to comply with the code. But that is obviously discretionary, and the real problem that exists in our submission is that the National Audit Office, in a report issued in February this year, indicated in fact that there are no checks on what is done by employers with material provided. And one sees that's memory stick 8G 2352, paragraph 4.15.
So which page again?
2352. Paragraph 4.15.
The code of practice that we have here as a revised one issued in November of 2015. Presumably there was a code in force at the time of the certificate we're concerned with.
I'm not sure there was, in fact, because actually, can we double check that?
Oh, right. There's quite an old provision, isn't it?
Yes.
Section 122.
Yes, no, I think that actually, my Lord's, I think probably right, that there would have been one, but yes.
Well, it would be helpful to know one way or the other.
Yes, no. We can provide, I'm sure between us we can provide that.
But in any event, the code doesn't seem to deal with our problem.
The code doesn't deal with our problem
The acquittals.
out of acquittals.
In fact, it's rather remarkable that all this material, which has been very helpfully produced, simply doesn't deal with that as a problem.
Well, to the extent it says anything, it just seems to treat acquittals in the same way as effectively as convictions. Well,
That's slightly odd.
Well, it seems to. There are, and the reason I say that is that if one looks.
No, I mean, if there's something here which refers to acquittals as a specific problem, then it'd be helpful to see it. But I don't think there is.
No.
We can obviously make our own view of how one deals with the material there is, but that's another point.
No, certainly as far as we're aware, there is nothing that expressly deals with the position of acquittals. The reason I just made the submission I did is if one looks at the guidance issued by NACRO, which is supported by the DBS, but is not statutory guidance, one sees in that's at tab 8D, one sees in that, for example, which, as I say, doesn't really add much, one sees there at 2241, a reference there, there's a sort of flow chart describing how material should be handled, and that appears on the face of it to equate convictions with allegations, essentially. It's at the top of the page. It's not easy to read. It says at the top of the page, dealing with convictions or allegations, and so there is, on the face of it, the only time allegations are referred to, they seem to be equated essentially with convictions.
Yeah.
And one sees then, just to sort of put that in context, 2229 is a flow chart dealing then with how one deals with disclosure. And one sees under that, in the context of that flow chart, essentially, process which talks about relevant information, doesn't distinguish essentially between convictions and allegations. It does have it does indicate that there should be a discussion with the applicant, who should indicate whether the information is correct. The problem with that, again, which is a particular problem that arises in relation to the acquittals, if one has limited information such as that in the certificate in this case, it is correct information. There's nothing incorrect in the certificate. Nothing there indicates that one's looking at the underlying allegation. The problem here, as I say, is not that the certificate is incorrect, It's just that the certificate says little about how reliable the allegation is.
The only place which does sort of deal with acquittals is in the Rochdale, I assume it's Rochdale guidelines in tab 8B, MS 2197, for example. We have a sort of flow chart of what's to happen where someone's awaiting trial.
Yes.
And we see that deals alternatively with guilty and acquittal.
Yes.
An acquittal seems to result in a safeguarding strategy meeting.
Yes.
And possible email to agencies, police for comment statements and officer availability. I mean, do you know what? That seems to suggest that the police might be asked to attend or something to explain.
That I think that's appears to be envisaged in the circumstances in which effectively the information comes to light during the course of a trial or during the course of a trial process. It's pretty unclear as to.
Doesn't help one as to what they do with the information.
Yes, and in fact, two things I should say about this guidance. This guidance, I think, is in fact Greater Manchester's, but we understand. Certainly, I think we understand it's something that is the nearest anyway to Rochdale policy that we can find. What one also sees, just one has that open, 2177. Talks about effectively how one handles information that's provided, whether it's conviction, cautions, or other information, sets out factors that are relevant. What it doesn't indicate is the reliability of the allegation is a relevant factor.
So you're saying this isn't Rochdale?
This isn't Rochdale.
The
this
index
is Greater Manchester.
The index says it is, but you say it's wrong.
I think we believe it is applied by Rochdale, but it's actually issued by.
Well, no, I just want to know what it is.
Yes.
If it's Greater Manchester, then that's.
Yes, it is. One sees on, just to put it clearly, one sees on the page 2174 that's issued by Greater Manchester.
Well, that's what I thought. The index says it's Rochdale.
Yeah. So the guide, as I say, the problem that one has in this case is that risk of repeating myself, that the information provided is extremely limited. It doesn't really assess assist a licensing authority or an employer to assess how reliable that information is. Reliability must be a relevant factor. But the guidance doesn't give any assistance on how the employer, who's ultimately left to assess reliability, should approach that.
Well, you have 2 minutes left. Mr.
Sorry, my Lord, I'm almost finished. All I would add to that, just to the points I've just made, is that the other final problem that one has with this guidance is that this guidance doesn't also indicate how an employer themselves should handle this material in a manner that's compatible with Article 6.2, and we would submit there is an issue in relation to that, because if an employer treats someone essentially as guilty of the offence, particularly for a public sector employer, that may raise issues. Allen, paragraph 103 and 104, very quickly, talks about how public authorities need to avoid treating someone as guilty of the offence. But one doesn't have anything in this guidance to indicate how an employer should, particularly a public sector employer, or how a licensing authority should treat this material in a way that's compatible with Article 6.2.
You say Article 6.2 extends to employment by public authorities?
Yes,
what about the trial process at all?
Well, it's not. I mean, it's quite clear. It's not just about trial process.
Well, and things that go with it. But yes, all right. You say it extends to this.
Yes. Okay. Well, Lords, I hope that covers everything. Well, Lords, I hope that covers everything, and I think I'm just about stuck to my time.
Ms. Davies? Ms. Richards?
My Lords, there are three central points which we seek to make arising out of the matters which the Supreme Court itself has raised since the last hearing. The first is that the Court of Appeal's decision on Article 6.2 did not, in our submission, in fact, depend upon the information in the certificate being limited to the bare facts of the charge or acquittal. I shall deal with that briefly because my learned friend Mr Moffat will deal with Article 6.2 to the extent that the court requires that issue to be addressed. The second point, which I will deal with in greater detail, is that the disclosure text in the present case, in our submission, was sufficiently informative to further the objective of enabling an informed decision to be taken by the licensing authority. Or put another way, it wasn't of such limited practical utility as to render the disclosure disproportionate. Thirdly, as to the use to be made of the information by those to whom the disclosure would have been made at the time, in other words, Rochdale Metropolitan Borough Council exercising its functions as a licensing authority, such material as this court has, and the document that my learned friend was looking at with my Lord Lord Carnwath a few moments ago, is Rochdale's document, not Greater Manchester.
It is Rochdale.
It's Rochdale's document. I can show you the necessary reference.
Oh, good, okay, I'll
But such material as
re-amend the statement at the end.
Yes, suggests that the information would be used precisely as the first respondent, and I believe also the Secretary of State, submit it should be used, namely as an alert to the licensing authority to enable it to undertake such further inquiries and obtain such further information as it considers appropriate, to enable it to discharge its entirely separate statutory function of deciding if an individual is a fit and proper person to hold a taxi licence. So turning very briefly to the first of those points, the Court of Appeal's decision, the relevant paragraphs are paragraphs 55 through to 60 of the Court of Appeal's decision, MS 158 to 9. Our submissions as to what the Court of Appeal in fact decided are set out in our written submissions in the supplemental bundle tab 2, MS 2086. And in short, we say, when one looks and reads together paragraphs 56 through to 60, that what the Court of Appeal in fact concluded was that this certificate did not cast aspersions on the correctness of the acquittal. It didn't suggest he was in truth guilty of the offence applying the criminal standard of proof. And it said in terms in paragraph 58 that a statement that allegations were more likely or not to be true on the balance of probabilities does not undermine the effect of an acquittal for the purposes of Article 6.2, because of the different and more exacting standard of proof in criminal cases. So contrary to the submissions of my learned friend, we say that what the Court of Appeal in fact decided was, first of all, this certificate did not contravene Article 6.2, but in fact, the certificate could have contained more information about the evidence and the opinion without contravening Article 6.2. Now that, as I say, will be dealt with in more detail by my learned friend Mr Moffat for the Secretary of State. But turning to the actual disclosure text, the reason why this certificate, no doubt, did not contain further detail and was expressed in the terms that it was is twofold. And again, we've dealt with this in our written submissions in the supplemental bundle, paragraph 8 onwards, MS 2088. Firstly, the statutory test is not balance of probabilities, that the chief officer is satisfied on the balance of probabilities that the allegations are more likely than not to be true. The statutory test is might be relevant and ought to be disclosed. And so the disclosure text quite properly reflects the applicable statutory test. Secondly, the text reflected the available advice such as it was at the time the decision was made. That advice comprised at the time the quality assurance framework, and in our submissions in the supplemental bundle at 2089, we've set out in some detail, and we've set out verbatim what it was the quality assurance framework said about how the text should be drafted, paragraphs 11 through to 13. I'm not going to go through that, the court has it in the written submissions. But the court will see that what the quality assurance framework asks chief officers to do is to provide a fair, balanced, concise and accurate and indeed neutral account within the ECRC. Now, whether one characterises the content of the ECRC in the present case as extremely limited or not, the text is not in our submission uninformative. And again, we've set out for the benefit of the court the text on page 2088, paragraph 8 of the supplemental submissions. The first part of the text tells the reader that the chief officer is satisfied as to the statutory criteria being met. The text then gives details of the allegation and information about the person making the allegation, all as required by the quality or as recommended by the quality assurance framework. So the reader is told it was a 17-year-old female intoxicated passenger in the taxi. The salient details of the allegation are set out. The individual says she was taken to a secluded location, forcible sex without consent. The date is given so that whoever's reading this has a sense of how long ago this was. And then, importantly, we say the applicant's response to the allegation is recorded, his case, as it were, when arrested. And then the reader is informed that it passed the CPS threshold, that the applicant was charged, that it went to trial, and that he was acquitted. Now, that information in our submission fulfills what we say is the objective of drawing to the attention of the registered body, in this case the licensing authority of the local authority, matters which may indicate potential risk. It is, as the Court of Appeal put it, an alert. It puts the registered body on inquiry. It is no part of the police's function in making disclosure to tell the registered body what its decision should be or how it should approach its licensing decisions, or in the case of an employer, its recruitment decisions. Indeed, it's no part of the police's function to form any view on such matters. It's not the police's function in making disclosure to try to persuade the registered body of a particular point of view about the facts. And the purpose is certainly not to ensure that the applicant is denied employment or a licence. The purpose is simply to put the registered body on notice that allegations were made which might be relevant to the decision which the registered body then has to make. And it is likely that that information will form but a part of the information that's then available to the registered body. And again, turning to our written submissions, MS 2093, paragraph 20, we've made reference there, 4 lines down into paragraph 20, to the statement in the review of the criminal records regime undertaken by Sunita Mason, it's footnote 4 to paragraph 20, that disclosure of information forms only part of a recruitment process. And we've made reference to the statutory code of practice. Mr. Southey has already taken you to that. It's the Secretary of State's code of practice. No doubt Mr. Moffat may come back to it. The information which we say in the context of the present case is particularly important is not speculation as to how a hypothetical employer might respond. This is a taxi licence case and a challenge to a specific decision of the Greater Manchester Police to provide the taxi licensing authority with information that a young female drunk passenger alleged that the applicant had forcibly had non-consensual sex with her. And that information is provided to the licensing authority because the licensing authority has its own statutory duty to decide if the applicant's a fit and proper person to hold a licence. Now, if my lords would turn to the Rochdale document, it's in the supplemental bundle tab 8B MS 2173. and my lords will see it's entitled Statement of Policy and Guidelines relating to the relevance of convictions and other information which may impact on the granting of a licence. The reference on page 2174 to Greater Manchester, it merely reflects the fact that Rochdale is one of a number of local authorities within the Greater Manchester area. But this is the council's document. We can assure you it was located on Rochdale Council's website, and that's where it was found and reproduced from. And we see, for example, page 2175, under the heading Statement of Policy about Relevant Convictions, note in the council's view, this statement and the guidelines that follow, etc. And the document is replete with references to the council. So this is Rochdale's own document. And if I can just refer the court's attention to a handful of passages, 2175, the last paragraph, last sentence, refers to each case being considered on its individual merits. Over the page, 2176, paragraphs 1 and 2 through to 4 set out the council's specific function. It's under the Local Government Miscellaneous Provisions Act to determine if an individual is a fit and proper person to hold such a licence. And then paragraph 9 says the disclosure of a criminal record or other information relating to criminal records will not necessarily debar an applicant from obtaining a driver's licence. Whether or not an applicant will be granted a licence will depend upon whether or not they can satisfy the council that they're a fit and proper person to hold such a licence, the burden in fact being on an applicant so to do. Paragraph 11 deals in terms both with convictions and other information.
It doesn't deal, I mean, I'm sorry, I don't want to stop. I mean, I find this a very useful document because it looks at it from the other side point of view, which is what we're concerned with. And one's trying to find some guidance as to what use the relevant licensing authority makes of the bare assertion that someone's been acquitted. And the striking thing about it is it deals with all sorts of other things, but doesn't anywhere deal with how you deal with someone who's been acquitted.
Well, might I come on to that in a moment
Yes.
as I go through it? In terms of process, first of all, in paragraph 11, page 2177, a number of factors identified: the nature of the issue, when it took place, date, applicant's age, other factors which might be relevant. Then over the page, I just asked the court to note, top of page 2178, that the applicant will have a right of appeal to the magistrate's court against any refusal of a licence. And then halfway down 2178 starts guidelines on relevance of previous convictions and other information, again reference to cases being determined on their own merits. Paragraph 5 on 2179 refers again to other issues or intelligence received from other agencies which relate to the character of the individual. And then we learn in terms of process in paragraph 6 that can be a licensing panel convened. It's a hearing, and we see from little a that save in particular urgent cases, it's a hearing at which the person can attend and be represented. And then you'll see reference at 6C to process maps in the appendices. I'll come back to those in a moment. And then if the court turns on to 2183, the italicised paragraph towards the top of the page refers to intelligence and other information which not resulted in a criminal conviction. Officers will sometimes be made aware of other intelligence or low-level information about an applicant which has not resulted in a conviction but which is relevant in relation to their character. Officers will give appropriate consideration to this information, will seek to consult with other appropriate agencies in order to ensure they have a comprehensive understanding. Where appropriate, will refer such information and intelligence to the allegations management process. Any additional information gathered through this process may then be taken into account at any subsequent licensing panel. One of the questions the court posed in its most recent letter to the parties was further information about the allegations management process. Can I say, first of all, that the document which the appellant obtained and put in tab 8 of the bundle at page 2358 is completely irrelevant. That's a document headed LADO, Process for Managing Allegations. LADO is Local Authority Designated Officer. It's a term of art under guidance relating to allegations made against those who work with children. So this is a completely separate process, nothing to do with the context with which we're concerned. Information about what Rochdale as a licensing authority will do appears in the appendices to the Rochdale policy. if the court turns first of all to MS 2195, you'll see the overarching process it results in a decision coming before a panel, and if the decision is to refuse a licence, you'll see there's the right of appeal to the Magistrates' Court and beyond that to the Crown Court. And then over the page at appendices 4C and 4D, you see the flowchart which provides a little further detail. They are largely the same. For present purposes, I'll just ask you to look at Appendix 4D, which is where the application for the licence has not yet been determined. And if we go down to acquittal, you will see then if there's a current or pending licence application, there are two actions there set out. The first may be the convening of a safeguarding strategy meeting. In other words, a meeting at which relevant local agencies involved in public protection will convene to discuss available information and seek to obtain further information. And the second is email to agencies, local authority services for police, for comment, statements with officer availability to attend proposed licensing panel in the next 6 to 8 weeks. So that's an information gathering exercise on the part of the local authority, which may include going to the police for further information, no doubt to the police who actually had involvement with the investigation itself, a further investigation, with a view potentially to having evidence that can be put before, considered by and tested before the licensing panel.
But what I'm trying to get at, I understand the way you put it is very helpful, but are you saying that part of this process might be going back to the police body which issued the enhanced certificate?
Well, it wouldn't be going back to those who issue the certificate.
No, it'd be going back to the police who were involved in the trial.
Precisely.
And saying, do you think this chap was guilty?
Well, my lord, there's nothing to suggest it's put precisely in those.
No, but that's what I'm trying to get at, because I think it's very important as whether this process envisages simply alerting the relevant authority to the fact that there's been this acquittal and there's been the trial and so on, or whether at some point in the exercise it's appropriate for the police to express a view on likely guilt. You seem to be implying earlier on that that was acceptable.
Well, my lord, the police, in discharging their functions under the Police Act, the functions with which we are primarily concerned in this appeal, provide the certificate essentially in the terms in which the court has seen this certificate was provided. And that operates as an alert to put the registered body or the licensing authority on notice that this information is known to the police.
Yes, I got that.
It is then for the licensing authority, itself a public body, owing obligations.
Yes, I understand all that, but this envisages further input from the police.
My lord, yes.
And you're representing the police. I'm trying to get some indication from you as whether at any stage it's appropriate for the police who were involved in the original trial, saying, well, he got off, but we think that on balance he was probably guilty.
Well, my lord, we haven't been able to bottom out whether in fact that question has ever been put. What we would envisage would be the police being asked to provide further information about the underlying facts and available evidence if the licensing authority wants that.
So what do you say about the propriety of the police expressing a view as to whether he was probably guilty?
Well, my lord,
is that acceptable or not?
My lord, it's not a question which we would anticipate the police being asked or answering in those terms.
Well, let's suppose that they were asked, contrary to your expectation. Would it be proper for them to answer it?
Well, my lord, it depends proper in what sense.
Well, in any sense.
If my lord means, would it be a breach of Article 6.2 to say for a police officer to express that police officer's individual opinion as investigating officer as to the guilt of an offence? Those are not the terms in which the police officer, one would anticipate, would either be asked or would answer. Yeah. The police officer would perhaps be expected to provide information about the evidence that was available, may be asked to provide views about the reliability of the information from the person making the allegation, may be able to supplement by the
I can see it would be helpful. I mean, you could express a view about whether witness failed to turn up or something like that, or the case was dropped for lack of evidence. But what I can't believe is appropriate is for police to suggest a view as to how the cross-examination went, or perhaps it wasn't cross-examination very effectively. That can't be a proper thing.
Well, my Lord, it would, in my respectful submission, be surprising if the licensing authority were to pose questions.
No, but I mean, you're up to the police, and
it's
helpful to know what the limits are, because I think, what I think that it doesn't need to be, whatever comes out of this appeal, is some sort of better guidance as to what is and what is not appropriate.
Yes, and well, of course, the police merely act in accordance with such guidance as is available, and the guidance that's available is relatively limited. Well, we've cautioned against speculation, and I don't want to be unhelpful in not answering questions, but I don't have any information as to how in practice, or whether in practice a licensing authority has posed these questions to a police officer. I do have information in terms of Greater Manchester Police as to the numbers of cases involved, and cases in which acquittals are disclosed are very, very small indeed. So in the last 12 months, 11 cases in the context of 128,000 ECRCs. So, it may
Sorry, how many? 128,000
plus ECRCs. The vast majority of those contain only information from the Police National Computer. Information relating to acquittals in the last year disclosed by Greater Manchester Police, and we don't have access to national data, is...
So what happened in the 11 cases out of the 128,000?
Only 11 cases disclosed acquittal information.
Sorry?
11 cases in which acquittal information was disclosed by Greater Manchester Police in 2017-2018. And so there are very few...
The trouble with that is it suggests that those ones are the very ones which the police think the chap was jolly lucky to get away with it.
Well, no, my Lord, they will be cases, they may encompass a whole range of circumstances in which an acquittal was the outcome of the trial process for a number of reasons. They will reflect the fact that the Chief Constable considers its information, having undertaken some assessment of reliability and the other factors identified in the guidance and in the L case, ought to be disclosed because it might be relevant. But what's then done with that information is the obligation of the licensing authority.
Can it ever be relevant unless there is a risk that he did it?
My Lord, probably not. If it's so unreliable...
So the disclosure itself, together with the statutory test of relevance, is some indication, is it?
Yes, not...
There is at least at least a risk.
Yes, a possibility. If the police's firm view was that and one can envisage cases in which there's been a complete collapse of the evidence and an alibi has come to light, and it's very clear the police are able to take a forthright view. But disclosure will take place having regard to an assessment of all the factors identified in L. And yes, I entirely accept that it is an indication from the chief officer's perspective that this information might be relevant, that there is a possibility.
Ms. Richards,
not probability.
Following on, I'm sorry, I didn't mean to interrupt you.
No.
Following on from my Lord Care's question, would it ever be lawful for the police to say in response to a request that the individual may have performed the acts alleged, or that it's more likely than not that he may?
Well, my Lord,
that he did perform the acts alleged?
Although I think Mr Moffat may deal with Article 6 in more detail, in my submission, it would be lawful for the police to say that. And that's the effect of the Court of Appeal's judgment, we say in the present case. That they did not, on the facts of this case, go that far. And they contented themselves with a faithful application of the statutory criteria and statutory test. But we do see that they would have been entitled to go further and express a view on the balance of probabilities. My Lords, that's the Rochdale material.
Okay, before we leave it, can I just ask you, I just want to be sure I've understood it properly. The box that says safeguarding strategy meeting, etc., that's referring, is it to what? If applicable, were appropriate and necessary. So the possibility of there being a meeting of what exactly? Is it some local body, some local forum that brings together different agencies?
Yes, I mean, my lord, my difficulty is I'm seeking to construe a policy that's not the policy of the Greater Manchester Police. But yes, that's our understanding of it,
Well,
that it's a reflection of one outcome or one part of the process may be the convening of a meeting which involves relevant local agencies who may have information about
well,
an
who
individual.
might very well include the police.
It might well include the police, yes.
Yes, I mean, I don't think I'm asking you something which I can't reasonably ask somebody representing Greater.
No, my lord, it might well include the police, yes.
Okay. And it goes on, if concerned, formal request for licensing panel. So what's that meaning?
Well, my lord, as I understand Rochdale's policy, if there is different local authorities have different frameworks in terms of delegated decision-making for licensing decisions. And so there can be the grant of licence in uncontentious cases by an officer. I think what's being suggested here is if the safeguarding strategy meeting doesn't, as it were, address the concerns, the matter will need to go to a licensing panel.
I see.
The licensing panel, as we see from the remainder of the policy, the Rochdale policy, is a panel which effectively conducts a hearing at which the applicant for the licence attends and is entitled to be legally represented.
Yes, well, some of us have appeared before licensing panels, and I've never heard of it being dealt with purely administratively.
Well, my lord, it may be that's not the position, but I'm afraid I'm only seeking to try and construe what is set out here. The flow chart I have, my lord, I accept the rest of the flow chart tends to suggest that the matter will inevitably end up before a licensing panel in any event.
Yeah, and the other box, I take it is indicating that there'll be a request to other agencies who might have been involved. I mean, obviously, depending on circumstances, it might not just be the police, it could be a variety of agencies for comments, statements. And then the idea is that they want to know about officer availability to attend the licensing panel as a witness, presumably.
Yes, that's how I read it, my lord.
Yes, right, thank you.
And then, my lord, of course, there is then the right of appeal to the Magistrates' Court and beyond that to the Crown Court. My lord, the other information we have, again, in the context of local authority taxi licensing, is the document at tab 8F. And this is the Local Government Association, which is a body that is formed of most, although not 100% of local authorities in the country. It's a handbook or guidance it's produced. And then I just draw attention, bottom of page 2286, under the heading Decision Making. Decision making in respect of individual cases are often made by a regulatory licensing subcommittee. There's the suggestion that I think perhaps not always, but in controversial cases they are. This sits as a quasi-judicial body, must follow the rules of natural justice. Anyone affected has a right to be heard. And then there is then guidance set out from page 2290 onwards. At 2292, this deals expressly with soft intelligence. And the third paragraph, Mr. Southey has already referred you to. I perhaps emphasise the first sentence. When dealing with allegations rather than convictions and cautions, a decision maker, so that's the licensing authority or licensing panel, must not start with any assumptions about them. And then the sentence my friend referred to. And then it's good practice for the decision makers to go through the contents of an enhanced disclosure certificate with an applicant driver and see what they say about it. So, well, the important point is that the disclosure by the police in the ECRC, which is what is challenged here, is the beginning, not the end of a process. And the remainder of that process, in the context with which we're concerned, taxi licence is one in which the applicant will be directly involved. Of course, we have no material that's been put before by the court by the appellant to set out what, if anything, happened in the present case. My Lord, and just finally, there are a handful of points that I wanted to emphasise. Firstly, the inevitable logic of my learned friend's argument is that the licensing authority must take its decision in complete ignorance of the fact that a 17-year-old passenger alleged forcible, non-consensual sex by a driver. And the sole reason put forward for that is because a jury applying the criminal standard wasn't satisfied beyond reasonable doubt of the relevant matters that make up the offence. That, we say, would completely frustrate the purpose of the statutory scheme. And it is important to remember that what lies at the heart of this scheme and what is the justification for an interference with the rights of those in respect of whom information is disclosed is the protection of the vulnerable from harm. The two anomalous outcomes of the appellant's argument and our submission are firstly, and as I think was the subject of submissions on the last occasion, disclosure would be prevented in cases which passed the CPS evidential threshold, but not in cases which didn't reach that stage. And then secondly, dealing with the submissions on the text of the disclosure, on my learned friend's arguments, it would be more likely to be proportionate to give disclosure which contains the positive statement of opinions adverse to the appellant, than disclosure which sets out the key facts objectively and accurately in the way in which this certificate did. So, my Lord, for those submissions, for those reasons, we invite the court to reject the further arguments made by the appellant.
Yeah, thank you very much indeed. Mr. Morton.
My Lords, as you'll have seen from our written submissions in response to the questions from the court, we adopt very much the same position on the issues that my learned friend, Miss Richards, has been addressing you on, and accordingly I simply propose to adopt what she has said in relation to them. As she's indicated, it's proposed that the division of labour between us would be that I would address the Article 6.2 issue and respond to my learned friend, Mr. Southey's submissions on that. That, of course, being an issue on which the Secretary of State led the respondents' cases before the Court of Appeal below. Just before I move on to the Court of Appeal decision, just to pick up on one point that arose in questioning, I think, of, I can't remember if it was Mr. Richards or Mr. Southey, the code of practice for registered persons, there was in force at the time of this particular disclosure a previous version of the code of practice which was published in 2009, and will make a copy of that available to the court in due course. But insofar as we've been able to ascertain this morning, the relevant provisions are essentially the same as the ones that the court has looked at in the current version.
Good.
And we'll provide the court with a copy of that.
So, so you'll be able to answer questions about the proper contents of the code of practice?
I hope so. I hope so.
No, I mean, what I think has come across, I hope, is that I'm surprised that there isn't any guidance as to how to deal with acquittals.
Well,
to emphasise that an acquittal means what it says. You know, I mean, you've obviously considered this since you've got our further questions. Is it not accepted that it would be useful to have some guidance about this?
well, my Lord, obviously the question for the court is whether or not it's lawful.
Yes, I know, but I'm concerned about practice as well.
And I wouldn't want to commit the Secretary of State to saying that it would be useful that the Secretary of State would do that. But obviously the Secretary of State will listen very carefully and read very carefully the court's judgment. But one needs to be a little bit careful about assuming that guidance can in all circumstances be the panacea to any problems.
No, it's very difficult to formulate. That's
Yes,
why we
indeed.
want your help. You see, because there's two, what's being said is this disclosure here didn't say anything more than the bare facts of the offence. But it's being suggested, as I understand it by Miss Richards, that it could have gone further. And it could have gone further and said, well, actually, we think it's quite likely that he was guilty.
Well,
Now,
sorry.
it seems to me it's rather important that the Secretary of State should, in giving guidance in a code of practice, should have a clear view as to which of those propositions is correct.
Well, that as I understand it, your Lordship's talking about the guidance that's given to the police rather than to...
Well, they both hang together because they're both...
Well, they would... One
so
would
clearly
hope that
the
they would
guidance
dovetail.
to the police, when you get your certificate, you will see from the guidance of the police what it's likely to mean.
Yes. Well, your Lordship will appreciate, of course, that all of these cases are extremely fact-sensitive. That was a point that we made in our initial submissions in our written case to the court. As your Lordship has rightly recognised, it is not easy necessarily to identify the sort of guidance that the Secretary of State might give. And of course, there are competing interests at play here. My learned friend, Miss Richards, drew attention to the quality assurance framework, which emphasised the need for the police to adopt as it were, a narrative-neutral approach to giving disclosures in criminal record certificates, because there may be dangers in the police expressing opinions on all sorts of matters in a certificate, and it may be better for them to steer clear of that. And of course, it would be for the Secretary of State to weigh up whether or not, in her view, the balance tipped in favour of giving a bit more guidance to the police, which could, for example, say the police might say a little bit more in these sorts of cases, and to whether or not there might be countervailing issues that would suggest you shouldn't do that. But those are matters of policy, not matters of law. And I would be very wary myself of getting into making submissions on those sorts of issues when, if it's not a matter of law, with respect, it's not a matter for the court. It's a policy decision for the Secretary of State.
Can you help me on one point? That you did produce a helpful note to the court.
Yes.
Dated the 13th of April, which I don't think has got into the supplementary bundle, has it?
No, it was produced, unfortunately, it was produced after the supplementary bundle was approved, so I apologise for that. It's not inserted into the supplementary
but
bundle.
it had quite a useful, I don't know whether others have it, paragraph 5, it had a quotation from the QAF.
Which I think is in the supplementary bundle.
Is it? I couldn't find it.
So let me, I think it is behind 8C,
Ah, let's see.
and it should be
Yes, actually,
internal
you're
number
quite right,
9. I'll
yes.
find the memory
Yes,
stick.
it is. Actually, 2208 was the one I was looking at.
Yes,
What you
your
quote.
Lordship's
Yeah.
correct.
And at the bottom there, it says that, so there may not be sufficient evidence to secure a prosecution or even get a case to court, but there may be enough for police to believe that someone may pose a real risk. Now, is that an appropriate test?
Well, it goes
Following
back.
an acquittal?
It goes back to what my learned friend said about all of this, and this whole scheme is directed not necessarily at employers going away and deciding for themselves whether or not somebody actually did what they'd been accused of. In a way, it goes similarly to the question my Lord Reid asked of Mr.
Yeah,
Southey.
but is that the question? The police, the person who's filling in the enhanced certificate and saying, there's been an acquittal, is it relevant to provide an enhanced certificate? And is the question he or she should ask himself is, well, is there reason to believe that this person, though acquitted, may pose a real risk?
Well, it may be a relevant question. It's not necessarily the only question. The questions that the police are directed to consider are those that are set out in the statutory guidance. This is not statutory guidance.
Unless it satisfied that test, how can it be relevant?
Well, again, I'd agree with my learned friends. It's difficult to envisage the circumstances in which the police could properly decide, never mind the proportionality test, could properly decide that the relevancy test was met, unless they thought that there was sufficient in the allegation that indicated that the person might pose a risk in the particular context for which the certificate was being required.
So it is an appropriate test.
Well, I wouldn't want to commit to it being the only test. I wouldn't want to rule out absolutely any other circumstances. But in general, I would adopt what my learned friend said in response, I think, to the question from my Lord Hughes about, in essence, the police will be looking at risk, because that's what an employer is going to be looking at. As I said, an employer is not necessarily going to be deciding, did they do it, did they not do it? They're going to be deciding, on this information, does this individual pose a sufficient risk? Is there a risk that this individual might give rise to, which means I should not grant them this license, or I should not appoint them to this particular post? And it's all about risk. And this was a point that we made in our written submissions about the danger of being sucked into balance of probability tests and beyond reasonable doubt tests, because it's not about that in this context. It's about risk. And risk has all sorts of factors that play into it. And we gave the example in our written submissions of somebody who applies for a teaching job, who the police are very certain, or to a high degree of probability, committed a theft, but they were acquitted for one reason or another. In those circumstances, circumstances where the police have a slightly better than balanced probabilities assessment that someone committed a theft, in those circumstances it might not be relevant to disclose it for the test. But if it's of another offence relating to children, a much more serious offence, that plays into the risk assessment. It's not just about the likelihood, it's about what they were accused of. Lots of different issues play in this context, and that's why it's dangerous, in my respectful submission, to fall into the trap that the appellant seems to fall into, of judging this solely in terms of balance of probabilities and other tests which are commonly applied in adjudicative proceedings, where the purpose of the proceedings is to decide, did it happen? Because that's not necessarily the purpose of all of this. It's a very different exercise. It's about management of risk, and it's about allowing the bodies, the Rochdale Borough Council, employers in other cases, to manage that risk as they see best. Because they are the people who have to have these people under their jurisdiction, whether as licensed taxi cab drivers or as employees. And they are the ones who are, as it were, answerable to the individuals, the potentially vulnerable individuals who are put under the care or under the responsibility of the particular applicant for the ECRC. So it's a very nuanced and, whether it's complicated might be the wrong word, but it's much more nuanced than simply a balance of probabilities type approach. And did they do it, did they not do it type approach.
It's context dependent, isn't it?
Yes. As we're told, everything is in law. As Lord Stein tells us. So, my Lord, I appreciate that might not be, from your Lordship's point of view, a particularly helpful answer, but I'm very wary of trespassing into areas of policy, because certainly it's never been alleged that the Secretary of, well, it's never been alleged that the Secretary of State has acted unlawfully in any way at all in this case, and it's certainly never been alleged, even today, that the Secretary of State has acted unlawfully by not giving or amending any kind of guidance. So the issue is simply not before the court. So, with that in mind, I was proposing in the time available just to move on very quickly to look at the Court of Appeal's judgment, if I may, and just I hope to clarify the position in relation to Article 6.2. And it may be useful if the court were to turn up the Court of Appeal's judgment, which we'll find at Memory Stick 135. It's in the core volume behind the file, or the penultimate tab, I think. Lord, as a starting point, it's important to recognise what the Court of Appeal were actually dealing with, the submission they were dealing with here. And it's in paragraph 3 that the Court of Appeal, Lord Justice McComb, sets out what the argument was before the court. And it was about an ECRC in the form of this particular ECRC. So that's what the Court of Appeal were obviously considering. They were considering the facts of this case. And in order to decide it, they didn't need to go any further and give general guidance on what ECRCs may or may not say in other types of cases. And of course, there's no appeal against the Secretary of State, against the Court of Appeal's decision on Article 6.2. And to a certain extent, or to a very large extent, the points my learned friend makes about what may or may not be included in other certificates are academic, because the Court of Appeal and this court has to consider the certificate that was issued in this case. Lord, if before getting to the meat of the reasoning on Article 6.2, can I just take your lordships to flag up a point at paragraph 27, which is where Lord Justice McComb sets out a submission that was made on behalf of the Secretary of State, because it just puts in context what one's dealing with here, and it's a quotation from Lord Phillips in the Adams case. And Lord Phillips, as the court will see, expressed a measure of astonishment, I think it's fair to say, as to how the Strasbourg court had expanded Article 6.2 beyond its core purpose of somebody being presumed innocent until they're found guilty. And that was very much at the heart of the submissions before the Court of Appeal on behalf of the Secretary of State, that this type of situation, an ECRC type situation, is not one that's ever been considered by Strasbourg. it's not really ever considered anything that's analogous to it either. And therefore one should be very careful about adopting the approach that Strasbourg's adopted in very different types of cases and applying it in this sort of cases, unless it's very clear that that is required by the Strasbourg authority. And that, in a way, goes to a point I think that my Lord Hughes made about the consideration of issues around persons having committed certain acts in other types of proceedings, disciplinary proceedings, family proceedings, civil compensation proceedings, because the Strasbourg Court has considered some of those types of proceedings, and they've adopted a much more liberal approach to Article 6.2 in those sorts of cases. So if I can go on then to the discussion, the headings on the opposite page, paragraph 34 onwards, and Lord Justice McComb starts with a discussion of the Adams case, where that quotation from Lord Phillips comes from, and he picks up what Lord Hope said at paragraph 111, and he sets it out. One needs to be a little bit careful with this quotation because there's a typographical error in it. The principle that's applied is it is not open to the state to undermine the effect of the acquittal. What Article 6.2, that should read, does not do is forbid comments on the underlying facts of a case in subsequent proceedings of a different kind, such as civil claims for damages, when it is necessary to find out what has happened. So Lord Hope saying there, Article 6.2 doesn't stop the state commenting on the underlying facts of a case in different kinds of proceedings which might come later after the criminal proceedings are concluded.
That's from 111 of
That's 111 of Adams, yes, my Lord, of Adams. So Lord Justice McComb picks that up as the key thread, and we'll see later he refers back to it, and that's the essential summary of the law as it applies in England and Wales. If we go over the page to paragraph 37, we get reference to the next Supreme Court case, which is Soccer against Gale. And this was a case where Mr. Gale had been acquitted in another EU state of drug trafficking, but the judge in this country made an asset recovery order against Mr. Gale, finding essentially that the money had come from drug trafficking. So, in essence, the judge in the civil proceedings in this country found that Mr. Gale had done what he'd been acquitted of.
that again would be a difference of standard of proof, wouldn't it?
Yes.
Yeah.
Yes. Your Lordship's absolutely right. Lord Justice McComb sets out Lord Phillips's reasoning, but if I can skip forward to paragraph 41, where he begins his sentence importantly. So he's picking up what he sees as an important point made by Lord Clark in this case. And there was a certain amount of debate between, it was a seven-member court in that case as to certain points, but he picks out what Lord Clark says, and we can see that Lord Clark, at the bottom of the quotation, paragraph 60 of Lord Clark's judgment, that Lord Clark is endorsing, picking up what Lord Hope said in the Adams case. So just towards the bottom of the page, Lord Hope said at paragraph 111, the principle applied in Strasbourg is not open to the state to undermine the effect of an acquittal. It appears to me, Lord Clark, that that is indeed the underlying principle, and that if, as here and as in Adams, the effect of the acquittal is not undermined, then there should be no question of holding that there's any conflict with the presumption of innocence. So on the facts of this particular case, whereas I've just said, the domestic judge found, in essence, that Mr. Gale had done what he'd been acquitted of, albeit applying a different standard of proof, as my Lord Hughes pointed out. So that's not a problem in Article 6.2 terms. So again, this thread coming through that my learned friend Miss Richards adverted to in her submissions about the use of the language, the standard of proof that's applied, it's very much context specific. But what we see in the authorities is they're very much directed at undermining the acquittal, essentially the state saying that person should have been convicted. But can I then take it on to the quotations from Lord Dyson's judgment, which is at paragraph 43. And Lord Dyson was dealing with a point that, of course, Article 6.2 applies to persons who are charged with a criminal offence. And of course, once one's been through the trial process and has been acquitted, they are no longer charged with a criminal offence. So he was considering the circumstances in which Strasbourg has expanded the literal wording of the article to cover cases where a person is not, on the face of it, actually charged with a criminal offence. And he identified two different types of cases where Strasbourg has said Article 6.2 reaches into those cases, even though the person is not, in fact, charged with a criminal offence. And the first one he deals with in the quotation set out under paragraph 43, and it's where the subject matter of the proceedings is so closely connected with criminal proceedings that the convention protection should be available. And he gives an example of a situation which arises in the Strasbourg case law, where there is a right to claim compensation by a defendant, on the part of a defendant, when they've been on remand. And Strasbourg has held that because that is very closely tied with the criminal proceedings, in effect, the presumption extends into those proceedings and covers them as well. So that was the first route that Lord Dyson identified. Lord Dyson then identified a second route, and we can pick that up in paragraph 44, and the quotation at the top of the following page, where Lord Dyson is quoted as saying, there may be a further route by which Article 6.2 may apply, notwithstanding the proceedings are civil and they don't have the necessary close link. There is a principle that if in the civil proceedings the court decision contains a statement imputing the criminal liability of the applicant, then that of itself can bring Article 6.2 into play. So Lord Dyson is identifying, as I said, proceedings that are themselves very closely linked to the criminal proceedings, and even if they're not closely linked, if the language used is such to impute criminal liability, then that brings Article 6.2 into play. And then we get an expansion on that by Lord Dyson quoted in the following passage. The necessary link can be created by this route only if the court in the civil proceedings bases its decision adverse to the defendant using language which casts doubt on the correctness of an acquittal. The rationale must be that in such cases the court has chosen to reach its decision by explicitly finding that a criminal charge, perhaps a criminal offence might be the more appropriate word there, has been committed. If it chooses to reach its decision that way, then the protections afforded by Article 6.2 apply. But if the decision in the civil proceedings is based on the reasoning and language which goes no further than is necessary for the purpose of determining the issue before that court, and without making imputations of criminal liability, then the necessary link will not have been created. The fact that findings of fact in the compensation proceedings may implicitly cast doubt on the acquittal is not enough to import Article 6.2. So again, Lord Dyson very much focusing on the imputation of criminal liability. In effect, the state saying, this person committed the criminal offence. They should have been convicted. Lord Justice McComb then goes on to consider Allen, and I know your lordships have Allen in the bundle, in the supplemental bundle itself, but perhaps relevant to draw out some points from Lord Justice McComb's treatment of Allen, because of course the question for this court is not did Lord Justice McComb get it right, it's what did he decide. And if we go through to paragraph 51, we can see what the core of the complaint was in Allen and the nature of the language that the European Court of Human Rights was asked to consider. And the courts, the domestic courts, considering the challenge to the refusal to give compensation in Allen, talk about there being powerful evidence against Mrs. Allen. A reference by the Court of Appeal to the fact that new evidence might, if it had been heard by a jury, have led to a different result. So it wasn't necessarily the case that on a retrial she would have been acquitted. The comment that the Court of Appeal had no doubt that the judgment of the Court of Appeal Criminal Division does not begin to carry the implication that there was no case to answer. The Court of Appeal saying there was no basis for saying that on the new evidence there was no case to go to the jury. And then at the bottom, the Court of Appeal's judgment clearly implied that she could potentially have been convicted had she been retried. So that was the Strasbourg Court's assessment of what the domestic court's comments were, the effect of them.
That was unacceptable.
Sorry, I beg your pardon?
That was unacceptable under Articles.
No, that was acceptable.
That was acceptable.
That was acceptable on the facts of this case. If one goes up to paragraph 52 of Lord Justice McComb's judgment and paragraph 125 of the Strasbourg judgment, again, there's no single approach. Much depends on the context. In all cases, and no matter what approach applied, the language used is going to be critical. and then just picking it up towards the very bottom of that quotation, when regard is had to the nature and the context of the particular proceedings, even some unfortunate language may not be decisive. And then their decision, from my Lord Justice Carnwath's note, is in paragraph 134 at the bottom of the page, the quotation there, the court does not consider that the language used by the domestic courts in the present context can be said to have undermined her acquittal or to treat her in a manner inconsistent with her innocence. And again, picking up a sentence about 5 lines further down, the court did not comment on whether, on the basis of the evidence as it stood at the appeal, the applicant should be or would likely to be acquitted or convicted. So we can see the Strasbourg court allowing quite significant leeway in terms of the language used and holding that that is not a breach of Article 6.2 in this particular context, the second of Lord Dyson's context, where there isn't the link between the proceedings. And then that informs what Lord Justice McComb says in his own reasoning. Paragraph 54, to take it quickly.
Well, you better take it quickly because your time is up.
I appreciate that, my Lord, I'm sorry. Very end of paragraph 54, it's not open to the state to undermine the effect of acquittal. Paragraph 55, much depends on the context of the decision to be taken. The language used is important. Paragraph 56, what about the statement in this case? That was fine. Paragraph 57 at the very bottom, the context is all important. This is not a case where there's been an acquittal in a criminal court followed by link consideration. So it's the second of Lord Dyson's categories. And looking at the language used, it is not problematic. And paragraph 58, again, to pick up the point, a statement that the allegations were more likely to be true on the balance of probabilities does not cast doubt on an acquittal. Lord Justice McComb isn't saying that's only because it's in some reasoning which is held in a filing cabinet somewhere. That is a statement of his reasoning. He only comes on to the fact that it wasn't made publicly at the very end of the paragraph. And then at the end, paragraph 60, it's not said that the person, that AR was in truth guilty of the offence. It's implicit that it's alert. That doesn't undermine the effect of the acquittal. The effect of the acquittal is that the jury wasn't satisfied to the higher criminal standard. The effect of indicating facts from which others may perceive a risk doesn't contradict the effect of the jury's verdicts.
Good. Thank you very much. Mr. Knight.
My Lords, can I start by dealing with the submission, which essentially was primarily a submission to Mr. Moffat, that further information could have been included in this certificate compatibly with Article 6.2. And to some extent, the submissions were founded on several matters. Firstly, the Court of Appeal's statement at paragraph 58. Secondly, also the judgments of Lord Phillips and others in both Adams and Gale. Can I just remind the Court to view those matters in light of paragraphs 103 and 104 of Allen? I think the court obviously has access to Allen. Allen is in the supplementary authorities at tab 58. But 103 and 104 set out, and I made reference to them briefly in opening, but I think it's worth bearing them in mind, a sort of overview of the court's concerns that have resulted in the development of Article 6.2 jurisprudence. Paragraph 103 makes it clear that essentially innocence has to be, or findings of innocence have to be respected.
Well, 103, would you just like to read the first sentence of 103?
First, the present case concerns the application of presumption of innocence in judicial proceedings following the quashing by the CACD of the applicant's conviction, giving rise to an acquittal. I was going to come on to that.
That's the context.
Well, it is the context, but what then follows is obviously general statements of principle. I mean, that context, in one sense, is a context where the presumption of innocence applies less rigorously, one might say, because of the fact it was an acquittal on the basis the conviction was unsafe. One sees that, in particular, at paragraph 135, and it's the answer to the point my learned friend made about language, and I'll come on to that. But the end of paragraph 133 talks about the overriding concern being to ensure that the innocence of the person is respected. Paragraph 104 goes on to refer to the circumstances in which there may be a sufficient link between criminal proceedings, and such a link, it's said, arises in circumstances where, for example, there's a need to review the evidence in the criminal file, to assess participation in the events, or to comment on subsisting indications of possible guilt. And that's important in my submission, because that is the real problem in this case. While one might be able to rationalise criminal proceedings as not engaging Article 6.2 on the basis that ultimately the real question for the court will be whether or not a tort has been committed, and there may be an overlap, but there may not be. I mean, an example being perhaps self-defence under English law, which obviously is different in civil and criminal. So one can see how civil findings could be different because of the different nature of a tort. In this context, ultimately what is being assessed essentially is whether or not there is indications of guilt. That is, as I say,
I mean, the words comment on might be important because there's a great deal of emphasis in Allen on language, use of language.
yes.
I mean, to say we're refusing your taxi driver's license because we think that you may have raped the person who made the allegation against you would be one thing. To say we're refusing your taxi license because we think that to grant a license, because we consider that you're not a, well, it would have to be on the basis you're not a fit and proper person.
Established that you are.
Yes, you fail to establish you're a fit and proper person.
Well, except that, I mean, the problem with that might well be that, of course, you'd need to give reasons to explain what that conclusion as to why, and it may be quite difficult to give those to explain
Yes,
that.
it may take some gymnastics.
Yes.
What if they say, well, having considered the evidence that has been made available to us, we consider that there is a risk. Do you present a risk?
But the problem in practical terms will still be that the individual will say, I don't actually pose a risk because I was not guilty of these offences. You've got nothing else on the facts of this case to demonstrate.
Yes, but I mean, a risk is not eliminated simply by acquittal, inevitably, is it?
No, I accept that, but it comes back to this point about language and the I mean the importance of language. My learned friend, as I say, made submissions about how the language that was used in Allen was held not to be objectionable. But it's quite clear, if one goes to paragraph 135, one of the reasons for that was because in that case, all the Court of Appeal Criminal Division had decided was that the conviction was unsafe. They hadn't actually reached a verdict on the merits, and that allowed effectively greater latitude on the part of the subsequent courts in their judgments, because the courts were able to say, effectively, this isn't the case where you can establish innocence because all the Court of Appeal Criminal Division said was that your conviction was unsafe. That was, in fact, entirely consistent with the verdict in that case, but we're in a very different situation here. Can I move on, because I'm conscious of time, and I would agree with one thing my learned friend Mr. Moffat, I think, said, which is that, I mean, in some senses, ultimately, of course, what may be of greater importance in terms of what the outcome of this case is whether or not, in any event, the certificate on the facts of this case gave sufficient information. And that is an issue that my learned friend Ms. Richards addressed. And she indicated that what a certificate needs to do is draw attention to matters that may indicate risk. The problem, though, in our submission with a certificate that is as limited as the one in this case, is that puts the burden on the registered body, whether it be an employer or a licensing authority, to assess the extent of risk. But how does that body do that on the basis of limited information? I mean, my learned friend Mr. Moffat said, context is everything in this context. The problem for an employer or other registered body is how do they assess what the full context is? And my learned friend Miss Richards said it may be that the criminal record certificate is only part of the information, but of course we're looking at the situation from the perspective of the disclosing body, from the perspective of the police, and from the perspective of the police, they've got no reason to believe there's any other information indicative of risk. The reality is that an employee or a person applying for a licence is unlikely to say, well, there are these additional matters that indicate I'm a risk. The indications of risk are probably only likely to come from the criminal records check. Now, that is where guidance potentially is of importance, and I'll mention some general points about guidance in a minute, but just deal with the Rochdale guidance first. Again, looking from the perspective of the police had no reason to believe some guidance would necessarily have been issued. There's no obligation on a registered body to issue guidance specifically to deal with acquittals. There is, under the statutory guidance, an obligation to have guidance dealing with convictions. And that policy itself, as we've already seen, is limited because it doesn't give express guidance on how to deal with acquittals. Now, my learned friend says what it does suggest is that further information might be sought from the police. But my learned friend accepts there's no duty to seek that, and suggests it may well be quite unlikely for information to be sought about the reliability of the underlying allegation, and we would submit that's correct. And that means that one comes back to this basic problem that my learned friend says, essentially, it's for the registered body to assess risk. How can they do that on the basis of limited information? My learned friend Miss Richards indicates that actually this situation is relatively rare, certainly as far as Greater Manchester Police is concerned. But that in some sense is helpful from the appellant's point of view. Firstly, it implies that a registered body is likely to treat this as something that is not routine, which suggests there may be a specific concern. And secondly, it suggests that the burden of perhaps providing greater assistance is not necessarily great. My learned friend says there's no evidence as to what happened after disclosure in this case. The reason for that, quite simply, is, as the Court of Appeal made clear in A, my lords may remember that because A was at the heart of the arguments about the approach that should be adopted on review, the Court of Appeal made it clear one can't submit post-decision evidence. And the reason for that, quite simply, is that, of course, the police don't know what the effect of a decision will be. That's why cases like L emphasise that one has to work on the assumption, essentially, that people will be risk-averse. One doesn't know what will happen in practice. Finally, my learned friend Mr. Moffat suggested that the issues raised about the absence of guidance were a matter of policy but not law. In our submission, that's not entirely correct. Now, I accept there is no challenge to the absence of policy, and we're not saying at this stage necessarily that the Secretary of State has acted unlawfully by failing to issue a policy. That can be quite a high threshold to overcome. What we do submit, though, is that the greater the safeguards in place to ensure that information isn't misused, the more likely disclosure is to be proportionate, because the potential harm to the individual will be reduced, and the court can have greater security in reaching a conclusion that essentially material is likely to be properly used. So policy is important because it ensures essentially, or it helps to ensure that material is properly used. So it's not simply a question of policy in our submission, it is a question of law, and that's true despite the fact there isn't a challenge to the lack of guidance. If one doesn't have policy, it becomes more difficult to justify disclosure in circumstances like this. And that's, as I say, important in circumstances in which my learned friends both, I think, accept that allegations are not automatically a bar to recruitment. There's obviously good reason why allegations shouldn't necessarily be a bar to a recruitment, because they may be false. There are competing interests at stake. But that's where guidance is potentially important, because it helps people to ensure that they make only proper use of those allegations. Anything else? unless I can assist further, I think I'm...
Thank you very much indeed. Well, we're grateful to counsel for their further assistance in this difficult case. We'll consider the arguments and give judgment in due course. It's now adjourned.